pre-existing North Carolina statutory law. According to North Carolina General Statute 115C 390, school personnel may use reasonable force. The law reads, except as restricted or prohibited by rules adopted by local boards of education, principals, teachers, substitute teachers, voluntary teachers, and teacher assistants and student teachers in the public schools of this state may use reasonable force in the exercise of lawful authority to restrain or correct pupils and maintain order. Additionally, North Carolina General Statute 115C 391A in part references corporal punishment, suspension, or expulsion of pupils. According to the law, notwithstanding any school board discipline policies, school personnel may use reasonable force, including corporal punishment, to control behavior or to remove a person from the scene in those situations when necessary to quell a disturbance threatening injury to others, to obtain possession of weapons or other dangerous objects on the person or within the control of a student, for self-defense, for the protection of persons or property, or to maintain order on school property in the classroom or at a school-related activity on or off of school property. Please keep in mind, however, PCS policy prohibits the use of corporal punishment. Reasonable can be defined as that which is not extreme or excessive, moderate or fair, and possessing sound judgment. According to House Bill 1032, physical restraint means the use of physical force to restrict the free movement of all or part of a student's body. Physical restraint shall be considered to be a reasonable force when used in the following circumstances: as reasonably needed to obtain possession of weapons or other dangerous objects on the person or within the control of a student, as reasonably needed to maintain order or to prevent or break up a fight, and as reasonably needed for self-defense. Additionally, physical restraint shall be considered to be a reasonable force when used as reasonably needed to ensure the safety of any student, employee, volunteer, or other person present, as reasonably needed to teach a skill, to calm or comfort a student, or to prevent self-injurious behavior, and as reasonably needed to escort a student safely from one area to another. Finally, physical restraint shall be considered to be a reasonable force if used as provided for an IEP, Section 504, or Behavior Intervention Plan, or as reasonably needed to prevent imminent destruction to school or another person's property. Except as set forth in the before-mentioned circumstances, physical restraint of students shall not be considered a reasonable use of force, and its use is prohibited. The use of force by law enforcement officers in the lawful exercise of their law enforcement duties is acceptable. House Bill 1032 defines mechanical restraint as the use of any device or material attached or adjacent to a student's body that restricts freedom of movement or normal access to any portion of the student's body and that the student cannot easily remove. Mechanical restraint of students by school personnel is permissible only in the following circumstances: when properly used as assistive technology device included in the student's IEP 504 Behavior Intervention Plan, or as otherwise prescribed by a medical or related service provider, or when using seat belts or other safety restraints to secure students during transportation. Mechanical restraint of a student by school personnel is also permissible as reasonably needed to obtain possession of weapons or other dangerous objects on the person or within the control of a person, as reasonably needed for self-defense, and as reasonably needed to ensure the safety of any student, employee, volunteer, or other person. Except as set forth in the circumstances before mentioned, mechanical restraint, including the tying, taping, or strapping down of a student, shall not be considered to be a reasonable use of force, and its use is prohibited. Keep in mind, this shall not be construed to prevent the use of mechanical restraint devices, such as handcuffs, by law enforcement officers in the lawful exercise of their law enforcement duties. Seclusion. Seclusion means the confinement of a student alone in an enclosed space from which the student is A. physically prevented from leaving, or B. incapable of leaving due to physical or intellectual capacity. Seclusion of students by school personnel may be used in the following circumstances: as reasonably needed to respond to a person in control of a weapon or other dangerous object, as reasonably needed to maintain order or prevent or break up a fight, as reasonably needed for self-defense, and as reasonably needed when a student's behavior poses a threat of imminent physical harm to self or others or imminent substantial destruction of school or another person's property. Seclusion of students by school personnel may also be used when used as specified in the student's IEP, Section 504, Behavior Intervention Plan, and the student is constantly monitored by an adult in close proximity who is able to see and hear the student at all times. The student is released from seclusion upon cessation of the behaviors that led to the seclusion, or as otherwise specified in an IEP 504 or Behavior Intervention Plan, and the confining space has been approved for such use by the local education agency. When using seclusion as specified in the student's IEP Section 504 or Behavior Intervention Plan, one must also consider that the space is appropriately lighted, ventilated, and heated or cooled, and the space is free from objects that unreasonably expose the student or others to harm. Except as set forth in the before-mentioned circumstances, the use of seclusion is not considered to be reasonable force, and its use is not permitted. A reasonable use of force when used solely as a disciplinary consequence. This shall not be construed to prevent the use of seclusion by law enforcement officers in the lawful exercise of their law enforcement duties. Defining isolation. Isolation means a behavior management technique in which a student is placed alone in an enclosed space from which the student is not prevented from leaving. Isolation is permitted as a behavior management technique provided that the isolation space is appropriately lighted, ventilated, and heated or cooled. The duration of the isolation is reasonable in light of the purpose for the isolation. The student is reasonably monitored, and the isolation space is free from objects unreasonably exposing the student or others to harm. Time out. Time out means a behavior management technique in which a student is separated from others for a limited period of time in a monitored setting. Nothing in the new law is intended to prohibit or regulate the use of timeout. Aversive procedures. An aversive procedure is a systematic physical or sensory intervention program for modifying the behavior of a student with a disability which causes or reasonably may be expected to cause one or more of the following: significant physical harm, such as tissue damage, physical illness, or death, or serious foreseeable long-term psychological impairment. The use of aversive procedures in public schools is prohibited. Another way an aversive procedure may be defined is one that includes the obvious repulsion on the part of observers who cannot reconcile such extreme procedures with acceptable standard practice. For example, blindfolding or other forms of visual blocking, unreasonable withholding of meals, eating one's own vomit, or denial of reasonable access to toileting facilities, electric shock applied to the body, extremely loud auditory stimuli, forcible introduction of foul substances to the mouth, eyes, ears, nose, or skin, placement in a tub of cold water or shower, or the slapping, pinching, hitting, or pulling hair. Notice, reporting, and documentation. The annual distribution of new statute required. Each local board of education is required to provide copies of General Statute 115C 391.1 and copies of all local board policies developed to implement the new statute to all school personnel and parents and/or guardians of students at the beginning of the school year. Please visit the Pitt County Schools website for annual notice information. Additionally, there is required reporting of certain incidents. All school personnel are required to notify the principal or principal's designee promptly of the following incidents: any use of aversive procedures, any prohibited use of mechanical restraint, any use of a physical restraint resulting in observable physical injury to a student, or any prohibited use of seclusion or any seclusion lasting more than 10 minutes or beyond the time specified in a student's behavior intervention plan. Notice to parents. When a principal or his designee has personal knowledge or actual notice of any of the incidents mentioned before, the principal or designee must promptly notify the parent or guardians of the student involved and provide the name of the school employee the parent or guardian can contact regarding the incident. Written report to parents. Within a reasonable period of time, but not later than 30 days following one of the incidents described before, the student's parent or guardian shall receive a written incident report which must include the date, time, location, duration, and description of the incident and interventions, the event or events leading up to the incident, the nature and extent of any injury to student, and the name of a school employee the parent can contact regarding the incident. Non-retaliation for reporting. An employee making a report alleging a prohibited use of physical or mechanical restraint, seclusion, or aversive procedure shall not be discharged, threatened, or retaliated against through compensation, terms, conditions, location, or privilege of employment by any local board of education or any employee unless the employee knew or should have known that the report was false. Reporting to the state board. Local boards of education are required to maintain a record of incidents reported to the principal and parents under General Statute 115C-391.1J4 and provide this information annually to the State Board of Education. Limitations on liability. Nothing in North Carolina General Statute 115C-391.1J5, House Bill 1032, shall be construed to create a private cause of action against any local board of education, its agents or employees, or any institutions of teacher education or their agents or employees, or to create a criminal offense. Here is the pre-existing civil liability protection. Notwithstanding any other law, no officer or employee of a local board of education shall be held civilly liable for using reasonable force, including corporal punishment, in conformity with state law, state or local rules, or state or local policies regarding the control, discipline, suspension, and expulsion of students. Furthermore, the burden of proof is on the claimant to show that the amount of force used was not reasonable. Thank you for your patience. A few final thoughts. Use physical restraint as a last resort. Know what level of behavior the student is operating on, and help students talk out their problems instead of acting out their problems. Please feel free to call the Pitt County Schools Behavioral Supports Team with any questions. Have a safe and successful school year.